A warm welcome to today's webinar. Good morning, everybody. The Essentials of Estate Planning and Elder Law, offered by Elville and Associates Managing Principal and Lead Attorney Stephen Elville. My name is Jeff Stauffer, Community Relations Director with Elville and Associates, and I'll be moderating today's presentation. So we encourage your general questions today. So when you have a question for Steve, please note it in the questions panel on the right-hand portion of your screen, and we will take time throughout the presentation to address them. You also received the presentation slides by email from me this morning to take notes on them if you wish. The presentation is also available in the section marked handouts in the panel on your screen to download at this time. Everyone will also receive a post-webinar feedback email right after the presentation, and we ask that you please take just a couple minutes to fill out this very brief survey to offer your feedback about the presentation. And we read and value every comment that you have to offer us. Here at Elville & Associates, we want to be a resource to you for your families and your planning needs. So consider a consultation or a document review with Steve after today's presentation, and use today's education as a jumping off point to get your planning started or updated. Consultations are the best and most ideal way to get your specific questions answered, have Steve understand your individual situation, and help create solutions and a path forward for you. So briefly, I'd like to offer Steve and the firm a proper introduction before we get started. And then we have a quick poll, so we'd like to see who we have with us today, and then we'll get started with the presentation. So here at Elville & Associates, we were founded in 2010 by Stephen Elville, our managing principal and lead attorney. We have several different practice areas that we offer here at the firm, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, and tax planning and asset protection. We have 7 attorneys, 12 staff members, and 5 locations. And Steve and I are coming to you live from the Columbia Gateway Community location today. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. And we do focus on education a lot here at Elville & Associates, as many of you know. And we do that in several ways. Through our planning process with our clients, we offer over 100 educational webinars and workshops in the communities that we serve each year. And also by way of our accredited client care program. We're one of only 2 firms in Maryland to have an accredited client care program, or CCP as we call it here, accredited by the Client Care Academy in Boston. We also work with the ideals of client education, collaboration, and compassion in mind with every client every day here at the firm. A bit about Steve. His work as an attorney for the past 20+ years has been centered in elder law, special needs planning, and estate planning, with an emphasis in areas of tax planning and asset protection. A member of many different national membership organizations, the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys. He works to bring peace of mind to clients by creating solutions to their needs through counseling, client education, and the use of leading-edge legal technical knowledge. A very seasoned speaker, if you haven't heard Steve present before, presenting each year at many webinars, workshops for businesses and their employees, conferences, and continuing education events. Steve was also named to the Maryland Super Lawyers list for an 8th time this year and a 7th consecutive year. He also had a feature story written about him in a National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization he founded in 2014, and I'm very privileged to be the executive director of. So if you'd like to learn how we work to make a musical difference in the lives of children each day, I would love to speak with you further at another time, so please feel free to reach out to me. But for now, we're going to talk about estate planning and elder law. And I'm going to launch a brief poll here just to see who we have with us today, so Steve can tailor his presentation just a bit to our audience. And the simple question is, what brings you to today's webinar? And the choices are: 1, I am new to estate planning and need to get started. 2, I have a plan in place but is outdated and needs updating. 3, I feel my plan is on solid ground, but education is always great. And 4th, I'm an advisor here to learn to better serve my clients. So make the choice that best suits your situation. We appreciate you being here on this nice spring day. Hope you're going to get out there sometime to enjoy the weather before it gets chillier next week. They say about Maryland weather, if you don't like it, just wait a minute. So we'll give it another few seconds here. Okay, so we have 27% saying, I am new to estate planning and need to get started. We have 41% saying, I have a plan in place, but it is outdated and needs updating. That's not unusual. 26% say, I feel my plan is on solid ground, but education is great. And then 4% say, I'm an advisor here to learn to better serve my clients. So thanks for being here today, Steve. I'm going to go ahead and turn the presentation over to you.
Thank you, Jeff. All right, I am just going to take charge of that screen when I see it.
On the phone.
And Jeff, I'm not able to take over the screen yet.
Okay, let's take a look here, Steve. Let's try that
There
again.
we go. Now I can do it, and I'm going to go down here and get my slideshow started, and we'll get started here. Bear with me. Well, thank you, Jeff, for that wonderful introduction. Good morning, everyone, and happy spring. And it's just, boy, it's just fantastic outside here in Maryland, outside my window here in Columbia, and wherever you may be. Welcome to Elville and Associates. Thank you, Jeff, for a wonderful introduction and for getting us started. So I am excited to be with you this morning because we love to educate. And what better time to educate than the springtime? And thank you for spending your valuable time with us on a Friday morning, and I wish you a happy weekend ahead. So we're going to go through the next hour and 15 minutes or so of education, which is what we're known for. And I'm very privileged to lead a group of staff and attorneys here at Elville and Associates who are committed to education, along with our collaborative advisor teams, financial advisors, CPAs, insurance professionals, and others. And our goal here this morning is to educate you, to give you a mini master class on the subjects of elder law and estate planning, and to take your questions. We can't give legal advice per se, but we can talk about very high level concepts and basically get you pointed in the right direction if you have questions. But as someone said to me a long time ago, Steve, it's great to take people on a journey of education, but the issue here for a lot of people is to get them started, to give you a path forward. So that's what I want to make sure that we're doing this morning. I want you to have this presentation as a reference point, as a reference tool. You can take this PowerPoint presentation, and I promise you, if you get the gist of it, you'll know 95% more than anyone you know about estate planning and elder law issues, and even a little bit of special needs planning type issues. But as you use this as a reference, just know that action is what is important. And as a famous motivational speaker once said, about anything in life that we want to do, whether it's getting physically fit, whether it's eating right, whether it's starting a new hobby, or whether it's about estate planning, beginning is half done. So that's been one of my favorite sayings over the years. So with that said, this is a generally informal presentation. If you have questions, please let Jeff know. Jeff is an expert moderator. Jeff, by the way, I wanted to tell you that photo of me up there, I promise you that was taken just last month. It's not an old photo. So I just wanted to let you know that. But anyway, Jeff is a wonderful host, and he has done many, many webinars, and he knows how to take your questions and how to interrupt me from time to time if you have questions. But we will be stopping and intermittent points of the presentation to make sure that we're not missing any questions. So again, welcome. That's our introduction for today. Now, what we're going to cover is what exactly is estate planning and what is the process. And I really should have that word process capitalized, but it isn't. And it also should be bolded, but it isn't. Process is what makes the difference in good estate planning. Whether you've never done planning or whether you have an older plan that needs to be reviewed, which I know a lot of you have that situation. What can we do to make sure our estate plans actually work and that they don't fail? What we want to do is basically be intentional in estate planning, just like anything, but we certainly don't want to have an unintentional estate plan. And it's easy to avoid that if we just focus on the right things. We're going to talk about some of the very basic concepts around the country and around the world. What is the difference between a will and a revocable trust? And the underlying point there is, what is the difference between probate, a will, and non-probate? The idea of avoiding probate for those of you who that is important for. Then we're going to talk about the surface issues of elder law, taxation, and asset protection, because what we want to do is give you a scope. We want to give you a reference point that you can stand back and look at this information as you evaluate it, and you can have an idea, a real idea of what is going on. What is the lay of the land above and beyond these documents? Okay, what are the concepts? And we're going to talk about getting started and again, how to take the next steps, how to be proactive. And that's what's ultimately important in our estate planning and other planning, is that we are proactive. So we want to understand the estate planning process. And some of you who have done planning before may have done planning where there was no process at all. It was just a transaction. We're going to talk about that. We're also going to talk about why to plan, why we as individuals, each of us are going to have our own ideas of planning. And along those lines, I want to encourage you. I want you to have pen and paper handy. I want you to have a tablet handy. I want you to be thinking, what is my goal? What is my legacy? What is my purpose in this planning? Because if you have a goal, G-O-A-L, goal, and you can develop a purpose, right? If you have a goal, you can be driven, and then we know if you have the kind of counseling that you need, once you have that goal, we can really move together down the train tracks going in the right direction. And we are not off of the rails, so to speak. We are on the right track. So with the idea being that all planning is goal driven, why plan at all? Well, each of you have a certain family situation. No one's situation is exactly the same. What's the problem? Well, the problem is most estate planning documents look similar, and we're going to talk about that, but no person's plan or no person's situation is really the same. So we want to be aware of that. But back to why. The why really is providing certainty for some of you, providing smooth administration. Wow, when I really think about it, I really want smooth administration. I want to minimize costs. Some people say that. Some people are driven by protection ideas. How do I protect my spouse, my children, my grandchildren? How do I protect against remarriage if that's a concern for an older person? How do I eliminate taxes or minimize taxes? I want to understand those concepts. What if I have special intentions like charitable giving? What if I have a special needs child? What if I have another situation where there are just special reasons why I need to do this, this, and this to attain my goals? And ultimately, you want to be able to articulate your own reasons, your own definition of estate planning. Now, for those of you who have seen this presentation before, I apologize because the numbers I'm getting ready to articulate are not any different than they ever were. The majority of people in the United States have no planning. So let's just say 55% have planning, 55% have no planning is what I meant to say, and 45% have planning. So a minority of people actually do planning. We know that. And for some demographics, divorced individuals and certain other types of individuals, their non-planning goes up to about 62%, okay? Now, for young people, those young people who are 44 and under, generally speaking, 80% have no planning, and that's not surprising, okay? But once we understand these statistics, then it's important to understand another one, and that is for even the 45%, the minority of people who actually do planning, they actually are proactive. Now we want to challenge them to be slightly more proactive than that, because most of those people don't update their planning beyond the initial go round. Or if they do update it, they only update it about every 19 or 20 years. So that's not surprising, right? But we want to be aware of this, and good estate planning is not only getting started, but understanding that planning is not just a transaction, it is a lifetime process. And that's what I really want to drive home in the beginning of this presentation. All planning is goal-driven. All planning is proactive. Getting started is really the key. We don't have all the answers. You may not know what your goal is, but you want to get started. That's the important thing. Traditional planning is a transaction. Here is my will. Here is my trust. Here is my power of attorney document. That is my plan. No, that is wrong. That is a transaction with no education, no knowledge of the underlying document, except that it's a piece of paper. And what happens with those documents many times is they get put up on a shelf, and they don't get looked at again for a long, long time, or until, God forbid, there is a crisis. Versus a process that is really education-based, a process where there's updating, a process where there's hand-holding, a process where your trusted fiduciaries, your trustees, your personal representatives, your agents under a financial power of attorney or under an advance directive, your guardians, these people are educated about what you are doing and why it's important to you. So these things are diametrically opposed. The transactional process versus the process-driven planning that includes education and all of those positive things. Now, are there people who need a quick estate plan? Yes. There are people who are sick. There are people who are dying. There are people who are traveling. But generally speaking, if we have our way, if we had our choice, we would want to be educated and understand what is happening in our plan, all of the modern choices, and to have that kind of counseling. So the traditional estate plan, the one that many estate planners, including myself, were trained in, is the traditional mindset that we are focused on documents. There's no follow-up, there's no education, there's no maintenance and updating. And I think I've made my point there for most of you on the call this morning. And we don't want that. We don't want that because that is the first indication that our plan may not work. So think about this. If we put a plan together, we're very busy, we rely on our financial advisors and our lawyers, but our lawyers don't provide a path forward for education. We have just a transaction and we never speak again. Is there a chance that your plan will fail? Well, the answer is yes. It could fail for many reasons. People's addresses changed. You never got your assets properly situated in coordination with your plan. You had a life-changing event and nothing was updated, and on and on. So we want to make sure we have a process, and it doesn't matter whether it's a 3-step process like I'm showing here, or whether it's a 6-step process, whatever it may be. But the thing I want you to take away this morning is process and intention equals success in estate planning. So in a typical scenario for process, we might say that we want to take our time, be educated, and design and implement our planning. Then we want to maintain that plan throughout our lives, which is a long-term relationship with your advisors, your attorney, your CPA, your financial advisors, your advisory team, say. And then in the final administration, at the time of our passing, we will have a very, very positive outcome because we have a plan that is actually going to work. It's been updated over our lives. So that's a lot, especially for you all on the call this morning that are new to estate planning. You've never done estate planning. So I promise it's not as complicated as I'm making it out to be, but I'm trying to give you a solid foundation to start out on. You don't want to start on the tenuous foundation of thinking that your estate planning is just a set of documents. And that is a good thing to walk away from today's workshop with, is that one thing, that the documents are just part of the plan. The process really is the plan. And this process is kind of illustrated here with education, maintenance and updating, having advisors that care about you, having advisors that actually talk to each other and to your family. This is how you make your planning actually work in today's world. Now, if you have that tablet or you have a piece of paper, maybe you'll write this down. This is a very fundamental definition of estate planning. And we can define, again, estate planning any way that you choose, what is important to you, what's driving you. But one very simple definition might be estate planning is about disposing or giving away your assets at your passing to the persons or organizations that you want, in the way that you want, at the lowest possible cost. So in legal terms, we would call this disposing of your assets. And we might say in more lay terms, leaving our assets, leaving our property the way we want to the persons or organizations of our choice at the lowest possible cost. Now, there are other aspects of planning, as we're going to find out today. There's lifetime planning. What happens if I'm incapacitated? So your definition of estate planning might include having those necessary documents in place to ensure my self-determination in the event of my incapacity, not just what happens at death. So we're going to talk about that as well. All right, Jeff, I'm going to take just a sip of water here. I don't think we have any questions yet, but that's the first portion of the presentation. I'm going to let people breathe for just a second, and then we're going to launch into the discussion of the biggest question in estate planning, arguably, is do I use a will or a trust?
Thank you, Steve. Doesn't appear we have any questions as of yet. We'll keep going.
All right. Thank you very much. So when you approach estate planning, and many of you on this Zoom call this morning, webinar, you have an estate plan in place. So you understand what I'm talking about more so than others on the call. But let's just assume you are approaching estate planning for the first time. We are going to either have a will-based plan, and I'm going to show you what that looks like, and then we're going to come back to the prior slide. Here you see the will is the driving force of the estate plan, and we know that a will is subject to probate by its very nature, and we're going to talk about what probate is. Now, on either side of this will, we have powers of attorney for financial affairs. We have advanced medical directives for healthcare affairs. Now, going back to the prior slide, we see that probate, and this is a very simple definition of probate. This is not encompassing all aspects of probate, but this is just a general idea of the process of probate. And Maryland has a robust probate process, for better or worse. My colleagues in Virginia tell me that their probate process there is not as onerous. North Carolina has a similar process to Maryland, from what I understand, and so forth. But probate is a process, and it's a process of proving a will to be what? Valid. It's a process of saying, is this will valid? It's a process of giving notice to many people who are entitled to notice, and they have the entitlement to information. And there is an accounting required in many cases, not all in probate. There's a public oversight of this process. And after all creditors are notified and interested persons are notified, then the court will issue a final order. Now, let's take just a second here to test you just a little bit. And we're not going to be able to hear each other or to talk directly to each other, but I just want to give you a few hypothetical questions. What if I have a will and I've died and I have an IRA? Is my IRA subject to probate? Well, the answer is going to be no, so long as I have a beneficiary. Now, if I don't have a beneficiary, my IRA is going to be part of my probate estate, and unfortunately, bad things are going to happen, and that IRA is going to be taxable. If it's a traditional IRA, it's going to be taxed a lot sooner than I wanted it to be. That's not good. Now, the same situation, except for the tax, would occur with a life insurance policy. What if I have a life insurance policy? Is it subject to probate? Well, the answer is no, so long as I have a beneficiary. But if I have no beneficiary, now my life insurance, which would have passed outside probate, is going to go through probate. So that's probably something I did not want to happen. So I want to make sure with a will plan, I want to make sure that my beneficiary designations are correct. And that is not a small thing in the post-COVID world. That is the most important thing in a will-based plan. But let's go back to other assets. So if I have a joint account with my wife, if I'm married, or with my daughter, is that subject to probate? And the answer is no. That joint account is not subject to probate because by operation of law, it is passing on to the joint owner. What if I have a house in my own name? It could be a rental property, it could be a residence that I live in, and that is in my sole name and there is no joint owner. Is that part of probate? And the answer is yes. That's part of probate because that is in my sole name with no beneficiary, no joint owner. If I have a brokerage account in my own name, that is part of probate. So probate is the process of proving a will to be valid, and that will is going to control the probate assets, but the non-probate assets like IRAs with beneficiaries and so forth, that is not going to be part of probate. Now, that's still an important thing, but that's not part of probate. So can there be probate with no will? And the answer is yes. If I were to die or you were to die with no will, then our property would be subject to the laws of intestacy, the laws of Maryland that would dictate how the assets would be distributed. And that is listed in the Code of Maryland. So if I had that rental property in my own name, and I had that residence in my own name, and I had that brokerage account in my own name, regardless of whether I was married or single, and I passed away with a will or without a will, my assets are still going to be subject to the probate process before they can be distributed. Now, some people say, I want to avoid probate. I want to avoid that court process. Others say, Steve, I handled probate for my relative and it was fine. I never had any issues and I'm not worried about it. So I would say, generally speaking, most people want to avoid probate, but not everyone. So this is a counseling issue. What is the most important thing? The most important thing is that you have this basic structure. If you have this basic structure, let no one tell you that you don't have a valid estate plan. Regardless of whether you have a revocable trust or another advanced trust, this is the fundamental thing. What happens during my lifetime? This is the powers of attorney and advanced directives. I'm planning for incapacity. Also in the middle, what happens at my death? So what happens at death? What happens during life? And one last reference point to this slide, you'll see at the bottom there towards the end, it says the cost of probate. Now, the cost of probate, in my opinion, roughly speaking in Maryland, is around 4%. These are the statutory fees that are allowed in probate. In some places like New York, it's higher. I mentioned North Carolina. A colleague told me that it was about 5% in North Carolina. Take these numbers for what they're meant to be as illustrations. They don't apply in all cases because sometimes personal representatives don't take commissions, which they are entitled to. Sometimes people administer estates without professionals like lawyers. Sometimes it's just not going to be 4%, but roughly, I would argue that it's approximately 4%. So hopefully this gives you a frame of reference for today. Now we're going to talk about an alternative to a will. So if we're looking at basic estate planning, or we're coming back to evaluate our estate planning, we're really talking about wills versus revocable trust. Now, what in the world is a revocable trust? It sounds complicated, but it really isn't. And I want you to try to accept this, that it is not a complicated thing. And how do I know that? Because a revocable trust is nothing more than a substitute for a will. I can have a will, or I can have a will substitute, okay? I can go through a probate driven process, or I can go for a non-probate driven process. Now, if I create this trust, what is it? Well, it's just a reflection of me. It is a reflection of you. And it has two steps. You create that trust, you design it, and then we have to have our assets properly situated. And this is where most people fall down. If you're on this webinar this morning and you have a revocable trust, I want you to go back and revisit what is owned in this trust. Did I transfer my residence? Did I transfer my money market accounts, my brokerage, my stocks and bonds, my savings bonds, my savings accounts? Did I put my non-retirement assets into this trust? Because if you didn't, your trust will not work the way it's supposed to. So a revocable trust has two steps. We have to create the trust, and we have to align or fund the trust with our assets. So this is the nature of a revocable trust. It's a private document. It is a very nice management tool. It is not better than a will, and it is not worse than a will. It's just a substitute for a will. And it's for the person who says, my goal, remember, my goal is what's driving everything. My goal is to avoid probate. Okay. Now, there are ancillary benefits in many cases to a revocable trust. It's a superior, generally a superior incapacity planning tool. It is a nice lifetime management tool. It is not for everyone. However, what is it in reality? It does not protect from creditors, and it does not provide any tax savings. But it is a wonderful incapacity management tool, and it is a nice probate avoidance tool and a substitute for a will. So let's talk about what it looks like to have a trust. And here we have now the revocable trust as the driving force, okay? But you see, you still have those incapacity planning documents. You still have the powers of attorney. You still have the advance directives. And this is confusing. Why in the world do we have a will here? But you'll notice that will is in the background. That will is no longer the driving force. It is in the background. And that is just in case we own assets at the time of our passing, and those assets are not in our trust, but they should have been. So we want to have that backup will. And then the assignments that you see on the top right, that has to do with what happens to my tangible personal property, my furniture, belongings, jewelry. What happens to my intangible property, such as notes and loans that I've given to people that I'm being paid for, or royalties and that kind of thing. So the revocable trust versus the will-based plan, this is the foundational concepts of estate planning as far as the structure of things. But no matter what structure we are using, the basic concept I want you to walk away with today is I have to plan for what happens at death if I want to do good planning, but I'm also going to live for many years most likely, and I need to plan for what happens during life. I had a 105-year-old man in my conference room about a year ago, and that proved to me without any doubt, even though I'd have many ladies live beyond 100, it proved to me that we are on the right track to focus on incapacity planning, which we're going to talk about just in a couple of slides again. And with that said, I'm going to continue on. Now, we're going to take a break here in just a second for questions if we have any. But before I do that, remember that we have talked about two categories of how to leave assets at our deaths. But there are actually 3 categories, and we don't want to forget this one. So I'm going to use my hands, if that's okay again. And over here, we have a will-based plan. And on this side of the page, we have a revocable trust-based plan. But we have nothing in the middle, but now we do. And the middle category that I'm going to argue is what I would call non-probate transfers. We have wills that are subject to probate. We have revocable trusts that hopefully are not subject to probate because we've done the proper planning and the proper asset alignment. But now in the middle, we have non-probate transfers. Now, many of you recognize these right away. Joint ownership, no probate. Beneficiary properly designated, no probate. Transfer on death. I have my brokerage account and I died and I left it to my wife or my child, my spouse or my child, no probate, right? My bank account down at the bank is payable on death, no probate. Life estate deed. I just looked at one yesterday when a client had one. That client has a life estate, and at the remainder of their life, the balance goes to what is called the remainder beneficiaries, okay? There's no probate. Now, we are in a certain period of time here this morning, so I'm not going to spend a great deal of time on this, but I want you to use your imagination and I want you to use your common sense, because you do have that ability just through this computer to be able to do that. We have wills, and what happens if we die with a will? It controls where our assets are going to go because it's controlling our probate assets. In the revocable trust, it's controlling where things go. And what if we have an unexpected circumstance? What if we die, but the person that we're leaving assets to is already deceased and we never made any other arrangements? Well, now that trust or that will is going to have contingency provisions. What happens if this happens? What happens if this happens? When we also do modern planning, we can plan for asset protection, and we can protect beneficiaries from themselves and their own mistakes, and we can protect from divorce and other issues, car accidents and creditors. But we can also protect against what happens if someone is ill at the time of our deaths and the assets would have gone to them, but that person is so ill that they're going to need public benefits. Where I'm going is that wills and trusts can provide for contingency provisions, and that's why most people use wills or trusts to drive down their assets to their loved ones in a controlled and predictable way. These non-probate transfers are very important. We use them every day. You use them every day. But we need to understand that this particular middle category is not a substitute for estate planning. Here's an example. Let's say I have a brokerage account. I have all my money in there, and I leave it transferable on death. And that's what I'm going to show you next in this illustration. Here I have a wonderful will or trust. I worked really hard on it. I worked with my team, my lawyer. I worked really hard and we designed it. I went through all the education. But look at how my assets were owned. I had a transfer on death account because my financial advisor told me that I should. But look what happened. Everything that I have passed by way of these non-probate transfers. Now, maybe I was lucky and everything was okay, but maybe assets went in a way to the beneficiaries in a way that I was not expecting. Because I wanted my will or trust to control, but the assets didn't go through my will or trust. They went straight to the person or the beneficiaries, and it went in a way that I did not anticipate. Here is a different aspect of the same problem. I have spent a lot of time designing. I have worried. I have felt like I really accomplished something designing my plan, but my assets went in a way that I didn't expect. So funding or aligning the assets in coordination with my will or trust is the key. We don't want non-probate transfers to become our estate plan because we want to be intentional about how assets are going to flow down And we don't want minors or disabled people, or we don't want spouses who we're trying to control whether they can give it to a new spouse, or children who are at risk with substance abuse or other behavioral issues. We want to make sure that we're controlling the assets. Now, does that mean that we never use non-probate transfers? The answer is no. We use them in elder law, we use them in special needs planning, we use them in estate planning, but we want to use them as tools. We don't want to use them as the plan. Okay, so hopefully I have driven home to you that non-probate transfers exist for a reason. Many of you use them, but we want to understand why we're using them. Jeff, I'm going to stop just to see if there are any questions before we move on.
Thanks, Steve. No questions as of yet. I'm sure
Very
they're
good.
coming though.
Yeah, we probably have a lot of people writing, and I'm hoping they're writing or typing. Okay, so we're about halfway through the presentation. I want you to be congratulated for sitting through this. This is tough stuff and it's educational, but I promise we will get through it. Now, powers of attorney and advance directives. We've already talked about planning for life, which is planning for incapacity planning, as well as planning for death. So I'm going to tell you an anecdote right now, and let's look at what I'm talking about. Powers of attorney, Maryland happens to have a statutory power of attorney. So in planning, this is a power of attorney that's actually in the law. And then you'll notice that many estate planners use a general power of attorney in addition to the statutory form, which is beyond the scope of today's discussion. And then we see the advanced medical directive. Now, many of you have heard me say this before, perhaps, but if you were to ask top estate planners around the world, what is the most important document in estate planning? Most of them would say financial power of attorney is the most important document in estate planning. Now, why would they say that? Well, some of the reasons are depending on your perspective, but most of the reasons have to do with flexibility, the ability to plan for the future, a long-term future, and empowering your agents to be able to do things in the way that you would want them to do. And there are various levels of power that you can give your agents, but the big issue here is to understand the scope of the power and how much flexibility you're giving your agents. Now, on the advanced medical directive side, as you will see coming up shortly, many people feel that this is the most important document for them. And of course, healthcare decisions are extremely important. So what I'm driving home here is this: when you have agents for your financial affairs, and you have trusted agents on your advanced medical directive side for your healthcare decisions, you are avoiding guardianship. So the avoidance of guardianship is one of the keys in estate planning, and to know who is going to be our agent and why, and to ensure to the most degree possible that those agents always get along, always are collaborating, and would stay cool under fire if we become incapacitated, because we want to maintain what? Our right of self-determination, and make sure that we're never the subject of a guardianship. Now, is guardianship necessary? The answer is yes. It exists for a reason in our society to protect those who are vulnerable and need a guardian of their person or property. But in estate planning, our goal is to keep everything private and to never be subject to the loss of our rights in guardianship. Now, as a reference point for you, the Maryland statutory power of attorney is a great step in the law in 2010. There was a lot of fraud and abuse in Maryland, but that fraud and abuse had to come to an end because there were just no rules and not enough laws in Maryland in place to protect the public. So this Maryland statutory power of attorney exists like it does in DC and New York and Delaware and even West Virginia. But we want to understand its limitations and its utility. And for your own reference, I will not go through all of these slides this morning. For your own reference, you can see why this is an important thing to understand the differences and why we need to customize and be educated on the broad concepts of the general power of attorney and not just the Maryland statutory power. So I just want to make sure you're aware of these reference points for your own reference. Even though we do not have time to go through them all this morning, I've included them for your benefit. Now, as I said, many people feel the advanced medical directive is the most important of all the documents, although it's really not a contest of which one is most important. The big thing to take away is that no advanced directive is the only one. So what I mean by that is, at least under Maryland law, your advanced directive can be flexible, it can be customized. It doesn't have to be in any particular form. We recommend the Attorney General's form because it is easy to read. Many of our clients love it because it's so simple to deal with, and it has lots of places for customization. So as you look through this, you consider your own healthcare decisions, your end-of-life decisions. You consider whether you want those decisions to be written in stone, or like most people, you want those decisions to be flexible. You're going to make these very, very personal decisions. And the thing to remember is, so long as you have your mental capacity, you can change these decisions at any time. And that's true with all of your estate planning documents. The MOLST form is an initiative, or the MOLST laws are an initiative across the country in 2014, 2013, and 14. Maryland calls this MOLST, the Medical Order for Life-Sustaining Treatment. Many of you have heard of this by now over the last 10 years. For those of you who have not heard of this, this is a medical order that in some states is called POLST, the Provider's Order for Life-Sustaining Treatment, and it has to do with the continuity of care and an actual medical order about carrying out your wishes. So we have a video on MOLST. The Attorney General's website has a video on MOLST and other educational material. And in a one-on-one counseling session, we are glad to explain from our position as lawyers how we view MOLST as compared to an advanced medical directive and what is their relationship. But it's important for you to know, and arguably it's even more important for your healthcare agents to know, that MOLST exists. All right, Jeff, I'm just going to continue now until I hear that we have any questions. And I'm going to shift gears now. We've talked about having a purpose. We've talked about the difference between wills and trusts. We've talked about incapacity planning. And prior to that, we talked about a process versus a static transaction, and understanding that education is key. All right, now we're going to shift to taxation. We're going to shift to some elder law concepts. And again, thank you for hanging in there with me. Again, this is your reference tool as you move forward in your thoughts and concepts of estate planning. So our current estate tax environment is just off the charts, positive. Every individual in the country can leave $12,920,000 if you're a U.S. resident citizen. $12,920,000 of estate tax exempted assets. So your exemption is almost $13 million if you're a U.S. person. And if you are married, you have 2 times that amount, $12,920,000 each. So that means that you can leave upwards of almost $26 million to your heirs with no federal estate tax. It's unbelievable what has happened with these numbers. Now, these numbers are slated to go down in 2026, but right now they continue to go up based on a factor of inflation. And the Maryland tax environment is that we still have a $5 million Maryland estate tax exemption for each person. And if you are married, that means you can use the concept of portability, and that is down the list here a little bit. This is the ability of a spouse. I apologize if you're not married. This is the ability of a surviving spouse to use the $5 million or to use the $12,920,000 federal exemption of the deceased spouse and move that over to their side of the ledger so that that person has not only their exemption, but the exemption of the deceased spouse. So this is called portability. This came about during the Obama era. It is still very strong. There's no indication it will be taken away. So estate tax planning has been simplified for most people, not all people, but most. And the concept of portability, if you're married, is really important to understand. Now, again, for those of you who are married or maybe getting married, remember that in estate planning, one of the things we're concerned about is how are we leaving assets to each other? And do we want to protect against a remarriage? And there are various reasons why that would be important to some people and not important to others. Now, Maryland has enacted some pretty onerous laws that actually do protect surviving spouses very much, but they force spouses who are remarrying to consider whether they need to use a prenuptial agreement or not to protect their own children of a prior marriage. So there's lots to talk about here about the estate tax exemptions being very high. How do we use them? Do we elect portability on the death of one spouse? Do we want marital control, and do we want to protect against remarriage and have other asset protection features between spouses? But again, I'm talking a lot about spouses. If you are not a person who is married, your estate tax exemption in Maryland is $5 million, and you have a $12,920,000 estate tax exemption. And this is called the basic exemption amount. And it is a unified amount for gift tax and for estate tax. So in a one-on-one meeting, we can go into more detail about this, but I want to set the stage that for most people in America today, estate tax is not an issue. This, of course, is not the case for everybody because there are many wealthy individuals, but for the vast majority of people, they have much less than 10 million for Maryland purposes or 5 million for Maryland purposes. Not everybody. There are some wealthy people out there, and we deal with many wealthy clients here at Elville Associates, and moderately wealthy and not so wealthy. But most people in America who are married have less than $26 million. Thus, these rules have been simplified to help most people. Now, for elder care, as we start to get into the elder care type discussion, what is elder care or elder law versus estate planning? Well, there comes a point in our lives, God willing, we are healthy, and if we are not healthy, we are dealing with disability or potential disability. And we may be healthy at one point, and then at another point in our lives, after we've done routine estate planning, routine incapacity planning, we may run into a situation where we have disability, God forbid. And when we kind of have that disability kind of coming together with our routine planning, we've done some good things there. We've prepared for the disability because we have incapacity planning in place, and we've kept that incapacity planning current during our lives. We've updated our planning, but now our needs may have changed. There's issues with long-term care. How will we pay for the cost of care? How will my kids deal with my care? Do I want to preserve assets? Am I ready for this? Do I have enough income? Do I have housing that I need, or the proper assisted living or nursing home arrangement? So these have to do, Social Security issues, special needs issues, these have to do with elder care type issues. So elder care is where routine estate planning, traditional estate planning, kind of comes into the world of disability planning as we age. Now, this is not always the case. Certain wealthy individuals or people who never have health issues are not necessarily going to run into this transition of the routine planning that melds into elder care planning. But that is what elder law is a different type of estate planning that's focused on disability, long-term care, and asset preservation. Now, I was speaking with someone yesterday, and this illustrates most of the things on this slide right here. And the question was, how do we plan for someone who was a loved one? And how do we provide flexibility? How do we preserve assets and still have control of those assets? Well, believe it or not, under certain circumstances, we can do that under the law. We are blessed to be able to say, well, the laws are pretty liberal in this regard. And if we have done the proper planning, we can divest assets, meaning we can try to preserve assets for long-term care planning, but we can also preserve certain tax benefits and we can protect the assets from the claims of creditors. And we can do all of these things in kind of one fell swoop if we are fortunate to be in the right planning situation with the right family, with the right goals. So this involves Medicaid planning, planning for veterans benefits, which is a tax-free income for people that are older who are certain qualified individuals. And this is where the juxtaposition of estate planning with the traditional what happens at death, what happens during life for basic incapacity planning, this is where this melds into these other issues of asset preservation, housing, special needs planning for third parties or for spouses, Social Security issues. All of these issues are where we have this transition into elder law. Now, to understand some of these concepts, I find that it is very important to really delve into the issue of what am I talking about when we're talking about asset preservation or asset protection. So to give you the full scope of this information and to give you a reference point of how to look at this, I'm going to cover, as we get towards the latter part of our presentation here, I'm going to cover 3 aspects of asset protection, because some of you may have gathered just from the last few slides, well, Steve's talking about protecting assets from new spouses, like remarried spouses, protecting assets for my kids, protecting my spouse from creditors, or my child from creditors or divorce. What is that in comparison to protecting assets for Medicaid and protecting assets from nursing homes? So let's set the stage here just over the next few minutes to set in your mind the differences between these asset protection techniques. And for those of you who are Elville and Associates clients, or who may become Elville and Associates clients, we're going to be talking about these broad concepts of asset protection at our next client event coming up in the fall. Let's start out about where we all are, living our lives every day, and what do we have for asset protection just in our daily lives. And we don't think about most of these things, or we may not even know some of these things, but we have asset protection in this type of arrangement in our daily lives. So for those of you who are married and you own your residence, or you own other assets as spouses, tenants by the entirety, you have a very basic form of asset protection. It's not bulletproof, but it is a very basic form of protection that you do not want to be without. And we should make sure in most planning, not all, but we want to make sure that if you are married, that you own as many assets as possible as tenants by the entirety. Life insurance is protected from the claims of creditors in Maryland, so long as a spouse or child is the beneficiary. I have actually seen circumstances where no child or spouse was named, and there is a possibility that life insurance and its cash value is subject to the claims of creditors. So we want to avoid that if we can. Annuities are protected for the very same reasons as life insurance. Qualified plans such as 401ks, 403bs, 457 plans are protected from the claims of creditors. So you don't have to worry about that if you have a qualified plan. IRAs are protected from the claims of creditors, not as 100% bulletproof as qualified plans, but they generally, for purposes of this workshop, they are protected from the claims of creditors, especially if they are rolled over from a qualified plan. But if you pass away and you leave an IRA for your loved ones, non-spouse beneficiaries, those are not protected from creditors unless you plan to leave those IRAs in a trust for someone. So you can protect them in trust, but not if you leave them outright to a beneficiary. Now, domestic asset protection trusts in about 16, 18, 19 states, there are laws, not in Maryland, but there are laws that allow an individual to protect assets in a trust that is established by them in certain states. And there are various hybrid aspects of these trusts, and these are called self-settled trust or hybrid asset protection trusts and variations on those, such as in states like Delaware, Nevada, Alaska, Wyoming, those South Dakota, those types of states are asset protection states. But those are advanced planning concepts, and we do that at Elville and Associates, but this is not a routine type of planning there at the end there for domestic trusts. Now let's shift to a different type of asset protection. Having talked about the basic asset protection that's available to almost all individuals in a routine way, let's talk about Medicaid asset protection. Let's talk about protecting assets so that someone can get veterans benefits. Let's talk about what happens if there's an impaired spouse. Heaven forbid there's a spouse that's suffering from a long-term illness. Let's talk about what would happen if someone is single and they have not done any pre-crisis planning. So let's talk about the Medicaid Asset Protection Trust. So the Medicaid Asset Protection Trust, or what is called the 5-year trust, I presented on this the other day, and it is probably or arguably one of the most powerful tools, if not the most powerful tool in planning today. It allows someone to divest assets for nursing home preservation or other goals, and also be able to maintain a lot of the benefits of somewhat of a control over the assets, plus not losing the tax advantages of having transferred the assets, not losing the cost basis adjustment at death, and not losing the ability to protect the beneficiaries. So this powerful tool is called the 5-year trust, excuse me. The Veterans Asset Protection Trust is a similar trust, but it's designed to help a person who is an eligible veteran who would be eligible for a VA pension. And there are many VA pensions, but this particular one is called the VA Aid and Attendance Benefit, AID, Aid and Attendance Benefit. Then we have wills that are established under trusts, and Maryland has favorable laws about this. These laws were in flux for quite some time, but if you are a person who has an impaired spouse, you can take action. You can be proactive to get basic documents in place, but you can also prepare for what happens if you were to die first. You're the well spouse, and you actually preceded your ill spouse in death. You can still preserve assets for your family in a way that is counterintuitive, but the laws are very favorable for you to do this. So many people do this type of planning, and we will just call this a long-term care planning under wills and trusts. There's a way to do it under a trust, but the idea is to preserve assets should a well spouse die first, who happens to be taking care of an ill spouse. And of course, there's crisis planning, right? So when we are looking at a crisis, we are looking at a situation that has already occurred. So when that crisis happens, we want to be prepared with these basic incapacity planning documents, because that is why the power of attorney is arguably the most important of all the documents, in addition to other reasons that might have to do with taxes, they might have to do with business planning. But here we're talking about elder care. And as we wrap up this particular slide and move towards the end of the presentation, there is something called the rule of halves. So you heard me mention, what if a person is single, has never done any advanced planning, but at least they have incapacity planning documents in place? Under the current law, it is possible to save approximately half of the assets if a person is a single person, has done no planning, but has the flexibility of power of attorney control over the assets. And depending on the terms and provisions of that power of attorney, it may allow the agent to engage in asset protection, even if no prior asset protection planning was done. And then life estate deeds, which is a simple way of preserving a piece of real estate. It is simple and easy to do, but it is not flexible. And this is the ability of a person to transfer a house, a residence, to themselves for life, but give up the power to sell it. And if they give up the power to sell it and they do not apply for Medicaid within the 5-year period, what I would encourage you to think of as the look forward period, not the look back period, but the look forward period, now that asset could be protected. And that's the same concept of the Medicaid trust or the 5-year trust, but that trust provides more flexibility than just a simple life estate deed. But that life estate deed concept is available. And lastly, as we talk about asset protection, I'm now shifting away from lifetime protection, the things that we generally enjoy as protected during life, the asset protection concept for Medicaid and long-term care and veterans planning, versus the asset protection that we can do when we die. So as strange as it may sound, when we pass away, it is relatively easy to protect the shares of our loved ones. So it could be shares for spouses or children or grandchildren, nieces and nephews, anyone that you love that you want to protect. Now, what is protection? Protection could mean divorce protection, protection from lawsuits, protection from bankruptcy, protection from bad business deals, protection because my loved one is a doctor and they are subject to a lot of risk in their profession. So we can protect through what is called spendthrift trust. So when we pass away, we can leave irrevocable spendthrift trust for beneficiaries. We can structure those trusts with various degrees of flexibility. Certain special trustees, the use of special fiduciaries such as trust protectors, and we can carefully analyze whether we have done anything in this design of this trust that would actually cause a loss of asset protection. And this could be how trustees are structured, how flexibility is structured, and so forth. And of course, we do many, many special needs plans here at Elville and Associates, and we have been very, very blessed to be trusted advisors in the special needs planning community. So we take that very seriously, and we design supplemental and special needs trusts for the benefit of disabled loved ones, and that is part of planning for what happens at death. Lastly, on this slide, it is also possible to create trusts during life that provide asset protection, not just at death. But this is the general concept, the 3 aspects of asset protection that I wanted you to be aware of today. Now, as we start to wrap up, the Secure Act, many of you are aware of this now. President Trump signed this law in the latter part of 2019. It became law in 2020, and it exists today, and it looks like it's not going anywhere. To make a long story short, the Secure Act enhanced retirement planning for Americans all across the country in very, very big ways. But the Secure Act also now says that if you are a healthy beneficiary of an IRA and you receive an IRA, you must take out that money and pay tax on that within 10 years. And most of you have heard of this by now, and if you haven't, this is a big consideration in your estate plan and in your special needs planning if you have a disabled loved one. There are 5 types of individuals that are exempt from the Secure Act, and we don't have time to really go into all of that today, but those individuals are spouses are exempt, minor children, people that are less than 10 years younger than you, chronically ill individuals, and special needs or disabled individuals, and their special needs trusts are exempted if those trusts are drafted properly. Everybody else has to pay tax in 10 years because Uncle Sam is going to tax trillions of dollars, in my opinion, very quickly over the next few years due to the Secure Act. So all plans basically need to be reviewed. Not everybody has tremendous IRAs or 401k plans in their lives, but many people do. And we need to look at this and how it affects your planning. Now, as I mentioned, as we now wrap up, Elville and Associates, and Jeff mentioned this as well, we not only want to educate you, but we want to give you a path forward. Remembering that beginning, whether it's beginning your planning or beginning the review of your existing planning, beginning is half done. So we want to encourage you to know that we have a client care program. We believe in not only starting your planning and getting the initial phases done, but we want to give you a path forward throughout life to keep that planning updated so it will actually work. So we have a lot of fun in our client care program. We have social events, we have educational events, And many people, many clients want those things. And if you're interested in that, please let us know and we'll send you information. But the thrust of this, the real reason for the client care program is to make sure that clients have a path to keep their planning updated. That's really our mission. So I'm going to just skip over some of this client care information that you can read on your own, or you can talk to Jeff about this. And there are various aspects of membership. You get 2 hours of attorney time per year as part of the program, and so forth. But as we actually get to the last slide, before questions, if anyone has questions, I want to let you know, I should say, that we are here to educate and provide a path forward. We have 4 conference rooms here at Elville and Associates. 3 of those conference rooms are equipped with advanced technology to give you an experience that will allow you to do what is most important, and that is have the time to think. So we're going to talk about that here at the end. We want you to know that if you have the willingness to come forward and to just have a conversation, there's nothing to fear. And the reason for that is everything is confidential. When you talk to an estate planning attorney, even if you do not move forward as a client, you are engaging in an attorney-client relationship. So everything is confidential. So we encourage you to complete a questionnaire or to bring your documents with you. We encourage you to have an advisory team, your financial advisor, your CPA, your life insurance professional, and we want to collaborate with them. And if you don't have one, we want to help you kind of plan and organize that team that we believe is important for you. Of course, no one's situation is the same. We want you to prepare questions. We love to answer questions, and it helps our meetings become very interactive and engaging. So if you have questions, please bring those. And we want you to know that if you don't know what your purpose is in planning, you don't know what your goals are, our mission is really to give you the time to think. Most people today do not have the time to sit and think the way they should. So our conference rooms, our approach, our educational model is really to help you take the time to think out of your busy lives and to engage in this counseling process. And of course, we do not charge to, in most cases, to review documents that you may have. We don't charge for that. And our initial estate planning consultations are free. So our goal is to educate you and to give you a path forward and to give you time to think. So with that said, Jeff, I think we're ending just a little bit early. We have plenty of time for questions. And I want to thank everyone for taking an hour and a half of your time on a beautiful Friday morning. Thank you for your time and attention and your commitment to learning. And we both, Jeff and I, thank you, and we wish you a wonderful weekend ahead.
Thank you very much, Steve. Very comprehensive and thorough as always. And we will go ahead and start off with the question we have here. And I'll say, as always, now would be your time to get your questions into Steve. Great time to have Steve, who's right here with us right now, pose those general questions that you have to him. Great resource, as you can see. So we'll start off with our first one here, which comes from a good CPA friend of ours here at the firm. And that question is, confirming that the Maryland portability was in effect for 2014, there is a House Bill 179 that was enacted this year that refers to decedents dying on or after 7/1/2018.
Well, thank you for that reference. I will have to, look that up, and I'll have to confirm that. But I'm sure you're right about that if you are looking at the reference material for that in the code. So thank you.
Okay. So Richard will follow up with you on that, just to confirm. All right. No more questions as of yet, so I'll just say a A few things as for our webinar series, we move forward next week with a really popular presentation that we try to offer every 6 months or so, understanding the uses and purposes of irrevocable trusts in 2023, and that'll be offered by Steve at 10 o'clock. And then we have several in-person and virtual presentations for organizations over the next few weeks. So we'll be taking a little break with our webinar series. And then we come back on May 16th with a new topic, understanding hospice. Learn the facts and all its benefits. So take all your preconceived notions about hospice that you may have, just set them aside. We have Carlos Graverin, who's the executive director of Frederick Health Hospice, wonderful man who I've met, here to lead us through an educational presentation about hospice and all it has to offer. I've learned a lot from him already. I think he's going to do a great job and shed some light on hospice for all of us. Last thing I'll say is we do have several presentations set up for businesses and other organizations over the next several weeks. If your business or organization you're involved with has an interest in having Steve present on any topic that you've been involved in or would like to see us offer, reach out to me and we will certainly make it happen for you, either in person, which we love to do, or through our webinar series, which we've been very happy to do as well. Just reach out to me and let's talk about that and we'll make it happen for you. For some other questions, just some thank yous for a great presentation.
Thank you, everyone.
And so I think we'll go ahead and call it a wrap here for you, Steve. Thank you everybody for being here. We can be a resource, set up a consultation, anything of that nature. Please reach out to Steve or me and we'll certainly be happy to work with you. Hope you have a wonderful weekend and a nice day ahead. And we appreciate your interest in the Elville webinar series. We'll see you again soon. Have a great day.